Good afternoon and welcome to today's broadcast. I am Joseph Shepard. I am an attorney here at Wolfsdorf Rosenthal in Santa Monica, California, and we'll be discussing the L-1Z blanket petition process and how it can help companies in the U.S. Navigate and streamline the transfer process. Who can qualify for this, and how to make things as smooth as possible for onboarding or transferring in employees from qualified entities abroad. If you have any questions during the webinar, please feel free to type them into the window here, and if I can, I will address them during the presentation. If not, I will get to them at the end. And if, despite best efforts, we don't get to your question during the program, please email me afterwards at jshepard@wolfsdorf.com, and we can discuss from there. As a reminder, this does not constitute legal advice, and if you would like legal advice, you should consult with an attorney about it. This is for information purposes only, but nonetheless, I think this is going to be a good overview, at least for individuals who are maybe working in a global HR position or U.S. HR position and are interested in learning more about it and if their company could qualify. So let's start with the very basic. What is the L1 blanket petition? In general, it is a program set up that will streamline and allow larger multinational corporations to remove a lot of the red tape involved in transferring in their employees. You can think of it as set up for companies that usually rotate people in or are constantly transferring their workforce for short-term or medium-term assignments to come into the U.S. to speed up that process quite significantly and reduce a lot of the overhead and costs associated with an individual visa petition. To give you some perspective, as this is also part 3 of a so far 3-part series on the L's, the first 2 of the series dealt with what is an L1A, executive or manager, and what is an L1B, specialized knowledge transferee. I won't go into those during this program, but in general, you can refer to those previous webinars, and if you have any questions about it, please let me know. So the individuals have to qualify as L1A or L1B, but the usual process is you file an individual L1 visa petition with USCIS. With premium processing and an additional government filing fee, that can take best case scenario within 15 calendar days of filing, you could get an approval. However, recently, as many of you are aware, USCIS has been quite harsh on the L1 visa program, and we're seeing, in general, statistics that indicate something like 1/3 or even in some instances 1/2 of L1 individual petitions receive RFEs, which an RFE can significantly delay a case, even if it's filed via premium processing, because it may require a laundry list or 8 or 9 page list of things that they would like to see before they would be able to approve the case and give you, say, 12 weeks in order to produce it. So thinking about that in the larger picture, if you're trying to onboard someone who's literally about to ship all of their belongings and household goods to the U.S. and looking to get their family members to come with them, if you're still stuck in the visa transfer process because an individual petition is held up with USCIS, that can be quite a headache. So if your company qualifies for the L1 blanket, the good news is you would get to skip USCIS altogether, and the individuals can file the application for the L1 visa directly with the U.S. consulate or embassy abroad. So that is a general overview. What really the L1 does is it pre-certifies or pre-approves the qualifying corporate relationship between the U.S. entity that wants to receive the transferees and any of the entities listed on there that are foreign entities and are employers. So that has been pre-adjudicated and pre-approved, and it doesn't have to be re-adjudicated at the embassy or consulate, because the embassy or consulate will see on the blanket petition approval notice all of the listed entities there. So as long as they can show, here are my pay records and employment verification letter from the entity abroad, which is listed on the blanket, and I'm going to be coming in for a qualifying position at a U.S. entity listed on the blanket, they likely will be able to get the L-1 visa without hassle. The benefits of applying directly with the Department of State: you usually get a decision right away. They will not take 15 calendar days by paying an additional premium processing fee. The officer will let you know then and there whether or not it'll be approved, or if it requires additional administrative processing. Administrative processing, of course, can be a factor in any visa application, but 9 times out of 10 you'll be able to receive a response right away. As I said, USCIS is usually responsible for the individual petition process, and then upon approval, they issue an individual approval notice that the foreign national then takes to an embassy or consulate abroad to get the L-1 visa endorsed into their passport. The adjudication overall has already been done with USCIS in the individual context, and the Department of State is, in effect, making sure that there's no red flags or fraud, and the person is not otherwise inadmissible to be able to get the visa. In the blanket-based context, USCIS is only involved with the actual blanket pre-visa application process. They will make sure that all the entities listed and requested for inclusion in the blanket approval notice are in fact qualifying entities and part of this qualifying family of companies. And I do emphasize company. In the L-1 blanket procedure, it is for companies that are doing business and are engaged in commercial in some kind of commercial trade or services, provision of goods and services, and it does not allow for nonprofit organizations to be able to use the blanket. So in individual Ls, yes, nonprofits can have qualifying corporate relationships with foreign entities, and so you can do a valid individual L1 transfer with nonprofits and among them, but not in the L1 blanket context. It is for companies or established business entities that are doing some level of provision of goods or services and are employers, etc., which we'll get into in a moment. The Department of State then takes over the role of the adjudication. So it really does help a lot. There is one consideration, about this. While it does speed up the process overall, that is now contingent upon the speed of the individual embassy or consulate in order to process the visa. And so the website of that consulate or embassy becomes important because they may have specific intricacies or nuances about the application procedure itself. For example, in the U.S., among the U.S. embassy and consulates in India, only one of them is actually processing visa applications based on an approved L-1Z blanket. So it depends on the country and it depends on the specific post about where to go. Okay, so we've talked about generally what it is and what government agencies are involved, but how does a company know if it qualifies for a blanket? That's a great question. First, I would absolutely contact an immigration attorney who is experienced in all this. But to be able to even know if it's possible or even have an inkling of it, I think it's important to know what the base requirements are. The company and all the entities that want to be included have to be engaged in commercial trade or services. The U.S. petitioner must have an office in the U.S. That's been doing business for at least a year. So, for example, a new office would not be able to qualify for a blanket yet. They have to be able to be, you have to be shown to be doing business for at least a year, and that often means things like, tax returns, or if those are not yet available, at the very least, like a lease or invoices or payroll, etc., showing that you've had that at least 1 year, if not more. The petitioning U.S. company has at least 3 foreign and domestic subsidiaries, affiliates, or branches. At least one of the foreign entities is or will continue to be doing business as an employer for the full duration of the viability or the validity of the blanket, and at least one of the following is true. So this is not an all 3 have to be true. This is one of the following. Either a combined annual sales of 25 million among the U.S. entities, a U.S. workforce of at least 1,000 employees, and that's among all the U.S. entities, and or at least 10 L-1 approvals during the previous 12-month period. So these are, very, very strict rules about how you can qualify. So if you're a company, and many companies do, especially companies that have, say, large or highly technical and frankly very expensive industrial equipment, will be able to show combined annual sales potentially of 25 million. This is not looking at profit. We're looking at sales. We're looking at revenue, and this can be combined among the entities, to show this U.S. And so this is, again, usually shown through tax returns. Well, what if it's consolidated and it's not really necessarily clear where and from which entity contributes the revenue, or where the revenue was obtained, or anything like that? Annual reports, quarterly reports, anything may be filed with the SEC, or tax returns, usually would be able to demonstrate this. A company's tax return in and of itself is usually the easiest way to spot it. So if you know that your company or your family of companies is producing, revenue on an annual level of at least 25 million, and you have it, another enough entities all together, and at least one of them is going to be abroad the whole time, and you find yourself in a position where you are going to need to transfer individuals from among those offices, into the U.S. and into any of the U.S. entities that are listed on there from any of the foreign entities that are listed on the blanket. Or you've just been really busy and have done a lot of individual L1s within the past 12 months with USCIS, and if you have, I am, not envious of having to do that. Nonetheless, here is for like myself, someone who may be a visual learner and or just wants to see some examples. So listed on here as a just general, fictitious, made up family of corporations, and you can see petitioner here in the red is a U.S. Entity, and it has a subsidiary in the U.S. It also has a subsidiary in Norway, and it has 3, direct affiliates who share direct ownership with the parent company in Austria, and so again, we wanted to see subsidiaries, affiliates, or branches, at least 3 of those in the U.S. and abroad, and so I think we definitely have that. You can see here, 1, 2, 3. That's easy enough. What about combined U.S. annual sales of at least 25 million? Well, you have at least one direct affiliate who also has a subsidiary, but in relationship to the petitioner, it's a corporate affiliate, and we have another U.S. subsidiary there. U.S. petitioner and or the affiliate maybe file a consolidated tax return depending on the situation, and we're able to parse out and demonstrate to USCIS those annual sales. All right, so that sounds great. My company may qualify. How do I get, what do we do? What does the process involve? Well, putting together the L1 petition the L-1Z blanket petition with USCIS is filed there, and you file it. The company provides the proposed list of entities and evidence to support that each of them are in fact qualifying entities. They have a corporate relationship with petitioner. They're either a parent, subsidiary, affiliate, or branch, and that relationship can either be shown by, say, if they have a filing with the SEC that would list all of them, that's easy, or if they have tax returns that would list them. And in some cases it's not as crystal clear as this, and you really do have to include all of the formation and or ownership or purchase or transaction paperwork or share certificates, etc., to show that relationship for each and every entity listed, which is why in a moment we'll talk about how upkeep of the blanket is also important as part of your immigration overall compliance program at your company. So the initial approval is for 3 years, and so you have 3 years to test it out and see if it's working for you. But please note, if you do not extend it, if you let that lapse without filing an extension for indefinite blanket, then you have to wait 3 more years before submitting another blanket petition. So you have 3 years of doing individual petitions with USCIS, and then you can try again. So it's important to make sure to calendar the expiration date of the L-1Z blanket initial approval notice. But once you extend it, you file another application, you file another L-1Z petition with USCIS to show, yep, we're all still related, or here are the changes since the last one, and maybe here are some new acquisitions and all the corporate documents. Now, you don't have to necessarily, and this is in most cases, file all of the same corporate relationship evidence again. If nothing's changed on the list of entities, that's it. If there has been any changes, that's what you submit evidence for. There's been additions, you submit evidence for it. And they also, whenever you file this extension, they want to see who has been using it. So we've had the X, Y, and Z people come into the U.S. Utilizing the blanket, and here's the paperwork for it. If there are any material changes during the course of employment, that has to be notified to USCIS right away because it could affect eligibility. In addition, if for some reason the entire family of companies would no longer qualify under the blanket, that may affect the transferees in the U.S. on the blanket. So we suggest doing, as part of an immigration compliance program, at least every 2 years, if not every year, doing just a quick review of the entities listed on the blanket approval notice once it's indefinite, and even during the first 3 years, to make sure that they're all still there, and most importantly that there's still at least one foreign entity who's still doing business as an employer abroad, to which anyone in the U.S. could be transferred back to, should their employment end in the U.S. or their assignment end in the U.S. It doesn't have to be the same entity from which they transferred. It can be another entity in another country, but it is important that there still be at least that one in the U.S. for the duration. So you have your blanket approval notice, and really, who gets to take advantage of this? Well, so L1A managers and executives, if that's dependent upon the U.S. assignment, if they're coming into the U.S. to assume a managerial or executive role with one of the U.S. entities listed on the blanket, and they have at least 1 year of qualifying employment abroad with another entity listed on the blanket, they can do this blanket visa application procedure. Yay, they get to skip USCIS so much faster. Now, it's important to note, though, that there's some slight variations in adjudications between L1As at the embassy and consulate and L1As with USCIS. In practice, that is really the clearly approvable cases versus preponderance of the evidence. A clearly approvable case, that's the standard for the Department of State at the embassy or consulates. They can only approve the clearly approvable ones, and so that's a higher standard than well, supposedly higher standard than USCIS uses of preponderance of the evidence, which is just more likely than not true. So while USCIS anecdotally and from what we see is very hard on L1As and L1Bs, the clearly approvable standard, which is supposed to be higher, is what's involved at the U.S. embassies or consulates. And to be frank, each embassy or consulate does have some discretion and to how they adjudicate. And so we've seen some trends where some posts use that standard much more, hold themselves to only approving clearly approvable cases, or what they consider a clearly approvable case, more than others. So some posts do have reputations, and so I believe, once you have the blanket, even if you have it, it's not so much as here's the paperwork, go apply. It does involve some, some analysis of that specific post, or at least some knowledge of that post, to know if that's the way to go versus doing an individual petition. Now, once you have a blanket, you can do either. If you still wanted to, or if you had to because they didn't qualify for L1B, which I'll get into in a moment, you could still do an individual petition for them with USCIS if necessary. That may help if it's a maybe borderline L1A case, for example, to have the I-797 individual approval notice to give the foreign national before they get the visa endorsed, versus having that consular officer being, forced to make the decision as to whether or not it qualifies. Now, that's also important, because if the consular officer denies a blanket-based L1 visa application, there is no appeal. So keep that in mind too. You could ask them to maybe reconsider it if there's some, maybe there's a just gross error in the adjudication, but there's no appeal. At USCIS, if they deny an individual L1 visa petition, there is, the entire administrative appellate process, or just another refile. In addition, for L1Bs, there is a big difference between the blanket and individual in that specialized knowledge professionals. Specialized knowledge, as we saw in part 2 of this webinar series, was either advanced or special, and the Department of State uses very similar, just slightly tweaked analysis, but for all intents and purposes, it's pretty much the same. Special or advanced, but in addition, to qualify to use the blanket to apply for an L1B, the individual has to be a specialized knowledge professional. So have specialized knowledge and is a member of the professions. Now, member of the professions, in some cases, is interpreted to be has at least the equivalent of a U.S. bachelor's degree. Now that is interpreted slightly differently at different posts, and I think there is a little bit of room to say that it doesn't necessarily have to be a equivalent of a 4-year U.S. bachelor's degree. If someone has a bachelor's degree, period, or is a licensed professional, either one of those listed as the examples in the Immigration and Nationality Act, engineer, doctor, lawyer, etc. I think that there's an argument to say they do qualify as a specialized knowledge professional. I think each case is different, and it depends on the specifics, and it just depends on the specific post. But it is a big consideration, because a person with specialized knowledge can do an individual petition through USCIS, but if they're going to apply based on the blanket at an embassy or consulate abroad, they do have to qualify as a specialized knowledge professional. So keep that in mind for any L1Bs if you're deciding whether or not to do an individual petition for them versus an application based on the blanket. One of the other advantages of having someone transfer into the U.S. Under the blanket, other than just speed and efficiency of the adjudication process and onboarding and transferring in, if they need to work for any of the other entities listed on the blanket that are in the U.S. and they're going to be performing pretty much the same job duties, no material changes in what they're going to be doing. They are, say an engineer for a company A, and they're going to want to work for a company B, and they're both listed on the blanket. They can work for the other one. They can go start working for that other one, and there's no amendment required. However, if they came in on an individual L that was not done under the blanket, then they require an amended petition with USCIS, another amended individual petition, before they can start working for that other, and get it approved before they can start working for that other entity. So that is, kind of a big deal, especially when, large multinational corporations are always going through different various changes. If people are on blankets, there's less worry about whether or not, we need to do anything with USCIS before they can start working for, say, our branch office in New York, as opposed to our, main office in San Francisco. So that is one other helpful consideration. And another consideration too is, well, yes, you may do either one or the other, but you can't do both if you first filed a USCIS individual petition and it's denied. You may not then, the same person may not apply for the visa based on the blanket in embassy or consulate. So if you did USCIS first, you can't then turn around if it's denied and do the blanket. But the other way is appropriate, but only if it's denied by the Department of State first. So if the embassy or consulate says, no, this is not clearly approvable, sorry, then the individual may have an individual petition filed for them with USCIS. But they cannot do both, say, at the same time, and whichever one works. That's not acceptable or appropriate. That may factor into the decision as to whether or not to do an individual versus a blanket based. So if it's not clearly approvable, if the case is not clearly approvable, and that post is particularly strict about one particular issue, it may behoove everyone involved to do the individual process with USCIS. While it may take longer or not, the preponderance of the evidence standard will be applicable, and then once they have the approval notice from USCIS, they could go to the embassy or consulate and get the visa endorsed. So, with all of this in mind, and this is a very short presentation to give you an overview, I hope that was helpful for individuals who are considering potentially having their company try for a blanket, or they just want to know if the blanket itself is worthwhile. What are the benefits? What does it mean? I hope that I answered some of your questions during the program. If anyone does have any additional questions that they'd like to ask, you may email me at jsheppherd@wolfstorf.com, and or you can call us at 1-800-VISA-LAW, or one of our direct offices if you're already one of our existing corporate clients. Thank you all very much.